Can I work for another company while I'm here in the US on an investor visa? Good afternoon, everybody. My name is Charles Raether, and today I wanted to talk about this question because people often bring it up, and it's an important one that can lead to some serious negative consequences if you don't follow all the rules. So hopefully this video will answer those issues, and hopefully you listen through the whole thing because we got a lot of information packed in this next few minutes. Welcome back, everybody. And so to answer this question, if I've got an investor visa, so let's say you've got an E-2 or an L-1 or even an O-1. O-1 is a talent visa, doesn't require any investments. So sometimes clients they open their own company in the US and they're able to get an O-1 that way. So regardless of those, which one of those three visas you're looking at, whether it's an E-2 or L-1, where you're directly making investments in a business, or even an O-1, people often ask us, hey, can I still work for somebody else's business? And the short answer is no, you can't. So I don't know how many times I need to say it. You don't want to jeopardize your status, and you don't want to create problems. And so you don't want to go individually work for somebody else's business. Now, again, we're talking here in an individual capacity. So you as Joe Smith or somebody else, you can't individually go work for another company if you have one of these three very common visas. Now, if you have a spouse and you have, let's say, an E-2 or an L-1, your spouse receives an EAD, employment authorization. He or she can go work individually for some other business, but not the main applicant on the visa petition. Unfortunately for O-1s, spouses don't get work authorization, so I didn't even mention that for that scenario. But so what you need to keep in mind, though, is there is technically a workaround. You could have your company be employed by your friend. So if you've got some side business, your friend's got a business, he wants to hire you, help out, do some work, some programming, whatever, your friend can obviously hire your E-2 business or hire your L-1 business. That's completely legitimate. And that's really the only workaround you'd have in this situation. Now, let's say you wanted to develop another business line, like your friend has a business and he wants to sell it to you and you want to buy it and develop that business. Now, again, if you're an E-2 holder, let's assume, you could theoretically buy your friend's business, but you cannot actively play a role in it. And so that's where it's a very gray area. You could be the owner, the passive owner, but you'd have to have somebody else running your friend's business. Now, if your friend, wants to sell you the business and you're a nominal passive shareholder, but you're not doing anything, not providing any services, theoretically it could work. It's a little bit risky if they ever decide to look into these things. And we know under the Trump administration, they're looking under every stone and every couch cushion to find any possible violation. So you want to be extra careful. The other maybe safer alternative is if your friend wants to sell you his business, again, use your E-2 business or your L-1 business to acquire it. So your E-2 company could acquire your friend's business, and you're not threatening your E-2 status at all. You're not creating any conflicts or any problems. And it's completely legitimate for an E-2 business to expand operations, maybe acquire new businesses, open new locations, stuff like that. So again, that would be my recommendation is, if you're looking to expand or acquire other new businesses, don't do it through yourself personally, but instead do it through your company. I guess theoretically, you could have your spouse acquire that additional business if you don't want to do it through your company, since your spouse would have the EAD and there wouldn't be any questions if your spouse were providing services to that new business. That also could be, a possible workaround as well. But anyway, in closing, here's the one thing you got to keep in mind. I'm not getting paid is not a good defense. So they're going to look at the structure and the realities. And if they see you owning a business individually, for example, and they see there's no employees at that business, and there might not even be any subcontractors, and yet the business is generating income and conducting operations, they're very likely going to say, look, you're running the business. Even if you're not getting paid, you're not paying yourself a salary. If we can't point to other individuals who reasonably, we could argue, are running the business, you're going to be in just as much trouble as anybody else. So remember, the I'm not getting paid argument is not an argument with the IRS. In closing, again, here as with other related issues, always check with your attorney before making these kind of business decisions, especially if you're looking at acquiring new businesses. And the advantage of talking to your attorney too is not only to protect yourself from these problems, but also discussing how this acquisition of a new business or a new business line might actually help you in your immigration journey. For example, if you're looking at acquiring a green card and you currently have an E-2, if you structure this properly, you could accelerate your ability to get a green card, for example. So don't be afraid to reach out to your attorney. And if you really don't like your attorney, come to us, and we're always happy to provide guidance and suggestions for you how to achieve your goals here in the United States.